over recording acts, those of you that have taken first year property, I know that you have. I know Professor Durham teaches it, Professor Riley teaches it, I teach it. If you've had property 2, there's also a brief revisiting of the issue in that class. And the first multiple choice question I have on the front pages, I know the answer is D. I know in my heart that you will be asked a recording act question on the bar exam, and probably, possibly more than one. So this next page, I'm more or less go sequentially, but I want to hurry up and do some things so we can talk a little bit and make this useful time for you. I think it is important to look at this next page. This was provided to me by Professor Cochran and the good folks in the Bar Review People Bar Passage group. They're such an excellent resource to already avail yourselves of, and certainly after you graduate. But things just like this, I believe I also put this in my own supplement. This is the subject matter outline for real property. They also have it for the others. I want you to notice, and I won't go through everything, of course, but when you go down this first column, second column, etc., I believe you're going to see that we cover most of this. You know, how much did you get? That's going to be the issue. But that first column, you know, until you get down to the very bottom, fair housing and discrimination, I did not have the time to cover, and I frankly don't know what kinds of issues they would ask on a bar about that particular topic. But President states, you know, does it really exist? Yeah, and it's tested. Co-tenancy, future interest, landlord-tenant, the covenants, the easements, you know, now we get in that second column. There's a few things you're going to see there. I, for one, you know, I believe Professor Durham Riley as well, not so much on fixtures, not really zoning was covered. So those are some issues. Perhaps not options within the real estate context. But and now, next page. Here's the pitch that I'll make for taking property 2 if you haven't. There is quite a bit that is bar tested, and this is the multiple choice part of the bar, but it certainly could be repeated in the essay part. But this is, you know, there you go, mortgages, not covered in first year, covered in property 2. And when you look at that, hopefully this will give you some comfort. Maybe it'll strike fear into your hearts, I don't know. Most of this was discussed. I think a little less here. Future advance mortgages did not discuss. I didn't. Perhaps Professor Durham did, and some of these issues as well. Subject to and assume. Sure, we did that. Due on sale, foreclosure issues. Yeah. Adverse possession. If anything in law school that you should remember from anything you do in law school, I firmly believe it's the 5 elements of adverse possession. If you don't, your future is doomed. Transfer by deed, etc. So, you know, it's most of it's there if you take 1 and 2. And I think it's, you know, should be reassuring to you. Now, what I want to do today is, and jump in at any time, try to simplify these Recording Act issues, get a sense of maybe where bar exam questions have come from, and I'm basing that on my exposure to what I have been provided with in terms of bar questions. Again, Professor Cochran being a great resource, she has provided me with sample questions. I'm sharing them with you. I've, in the past, included them in my own materials. And this past summer, I worked closely with Tara Caputo, who is a graduate of our law school and works with Barbary now. She also provided me with some multiple choice questions that I have shared on this particular topic. She shared other questions with me as well. So what we're looking at is a question that, I'm going to skip page 3 and then come back to it. If you would turn to page 4, I guess, with me. It seems to be in the grand scheme of, you turn the page and there's a question, and of course the first thing you have to figure out is, you know, where is this contracts, torts, criminal law, property. Once you get a sense that this looks like a Recording Act question, it seems to me that often the first question you're going to ask is, well, what is the Recording Act? Now we're going to turn back to page 3 in a minute, and there's 3 times: race, notice, and what I like to call notice race, but more other people tend to call it race notice, same thing. So either one of those two aspects or the combination of the two and create the three types of recording acts. But notice here, they might tell you, I've seen questions where it says, this happens, this happens, this happens, this happens, and at the end of the question it says, this jurisdiction has adopted a notice recording act. So that, at least that's one issue that you don't have to deal with. You now know what the recording act is. But I've also seen questions, and we have one in the supplement, where the very question itself is, our jurisdiction has adopted the following statute, blah, 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 blah. Is this A, race statute, B, notice, C, notice race, D, something else? And so you've got to have some sense, and it's not, unfortunately, I think it's trickier than you might think to determine what the statute is. As a quick aside, I believe it was Colorado, their legislature passed a statute, Recording Act statute, and the courts of Colorado said, that's a notice statute. And the legislature said, no, it's not. It's a notice race statute. So even the legislature and the courts of Colorado couldn't figure out what it was. And they had to actually amend their statute and say, at the end of it, this is a notice race statute, race notice. So I included, what, 4 examples here. Let's start with that, and then we'll turn back. I think the first 3 are pretty straightforward, but the fourth one, for me, is not quite as straightforward. Very few, I would, quite frankly, doubt very highly, I can't say with certainty, I would doubt pretty highly that they would ask you a question with a pure race or a race-only recording act, because they're so infrequently used. That's the race to the courthouse concept that dispenses with any necessity of determining whether the second or subsequent person has notice or not. It's just, North Carolina is an example that's often used, and I made the notation for your elsewhere on this supplement. Those of you that are interested in taking Ohio bar exam, Ohio actually does use a race statute for mortgages and oil and gas leases. Don't know if that would come up, but otherwise, in the vast scheme of things, deeds and easements and leases, you know, particularly deeds, because that's typically the kind of question they would ask. Ohio is, I believe, a notice jurisdiction. But they are race in some respects. So why is this a race jurisdiction, this North Carolina statute? If you look at this, perhaps the easiest and most simple way is I don't see any real reference about notice. No conveyance shall be valid, and we're talking, these statutes are usually worded when they refer to a conveyance, they're talking about the first guy. So, you know, in terms of the sequence, if I was deeded property, my deed is not valid actually against people who were then also deeded the property in the future. You shouldn't do that, but sometimes it happens. So the conveyance number 1 will not be valid to create a property interest against purchasers or grantees, and as number 2, unless, and the way they word it is from time of registration, I included the word recording, in the county. Meaning what? All I have to do, if I'm number 1, is record first and I win. Alternatively, this statute is telling me that if I don't record first and number 2 records first, they win. And there's no reference at all to notice. So that's the trick here, is that Otto can convey the property to Anna, and then Otto, he's not supposed to do this, but he can turn around and convey that exact same piece of property to Ben, and Ben, if he records first, he wins. And even if he knew about Anna. So this is the most simplistic, but the most, I think, unfair approach, and that's why most jurisdictions don't use it. So the next one I've indicated is notice. And I like to compare and contrast the Arkansas's Notice Act with Washington's notice, what I call notice race. And by the way, the reason I like to call it notice race is, we'll get to this, in a notice race jurisdiction, you first have to establish that I took without notice of prior transactions, and then I have to win the race. So it seems to me it's more sensible to call it a notice race than race notice, but you will certainly probably more likely see it referred to on a bar exam as race notice. Same thing. But back, these are really the same except for the italicized language. So Arkansas is telling people, if you don't record, you're going to lose to people that come after you. But not everybody that comes after you. They have to meet certain requirements. Subsequent purchaser, their statute includes mortgagees, in good faith for valuable consideration, and it actually has to be the same grantor. They use the word vendor. So if Otto conveys to Anna, Anna doesn't record, and then Otto conveys to Ben, if Ben takes in good faith, and you might mark next to good faith, without notice. That's really what they're talking. So they didn't use the word notice, so you can't rely on its presence or absence. You got to look for notice or something equivalent to it. But they're telling Ben, if you take without notice, you trump, I use the word trump, the prior grantee, even if you don't record before them. And we'll do a problem that shows that. And then contrast that with the next one. Washington says to Ben, our subsequent grantee, if you are going to win, you also have to take without notice, but then in addition, you have to record before Anna does. And you all know this, I'm pretty sure you remember this from first year. What I thought was more confusing was the Iowa statute. Let's go through that real quick. Iowa is trying to communicate to people that if you received an instrument, a document, a deed, an easement, a lease, or something affecting real estate, it's not going to be valid against subsequent purchasers, like in my example, Ben, who take with valuable consideration. We're going to call that type of person a BFP, bona fide purchaser. So Ben is a bona fide purchaser, and you got a document prior to his receiving a document, you're going to lose. Let me start over. So no instrument affecting real estate, such as a deed, will be valid against somebody else without notice unless filed in the office of the recorder. The reason I thought, I don't know if you share my views, that kind of looks like a notice race jurisdiction statute, doesn't it? Because it says you got to take without notice, but then it has this comma, and then it has this clause about unless filed. And so at first blush, it says, well, isn't that, I think you could get tripped up. Isn't that like the Washington statute? And that's where you have to read these things carefully. This particular statute, the unless filed in the office of the recorder, is really a reference to the first grantee. It's not a reference to the second grantee. And it takes some time to see that. They're saying to the first grantee, your instrument, the way I read it and explained it below is that filing is one way to give notice. So Iowa construes this statute to be a notice statute. Now, again, would this issue ever come up? Well, I said I'd go to page 3 next, but I'm changing my mind. I know it's here somewhere. There's a bunch of questions in the back, and I know, if you turn to page 11 in the handout, and these are, I don't remember if these are MBE release questions or perhaps questions that were provided by Barbary. I have both. But look at question 7. This is a question that either was on the bar or Barbary thought it's the type of question. I think Barbary actually uses questions that were recycled. So this is what I call a bar type question. And there you go. The question simply is, can you figure out what the statute is? Any conveyance of interest in land other than a lease for less than a year, so got an exception, shall not be valid against any subsequent purchase or value without notice thereof, unless the conveyance is recorded. Is it A, B, C, or D? To me, it's pretty clearly, first of all, B is top point. But that's common, isn't it? You know, to eliminate the one that doesn't make any sense. And I hope that we can all eliminate D because of the reference to without notice. And it brings us back to A or C. And the correct answer is A. This is really verbatim the one we just went over. I provided then to you on the several pages later, I guess page 14. This is not my doing. This is the answers. Again, I think this is a Barbary question. So Barbary provided both questions and their suggested answers. So when you walk, although I don't think their suggested answer is particularly helpful here, but they just simply say it is A, and then they go on the next page to say why it's not the others. Frankly, not a lot of explanation, just simply they give you an example of a statute that is a race notice statute. So there's a question that may or may not come up, and you want to spend some time in your bar exam review time to think about whether we have that type of statute we have. Again, what are you looking for? Is the statute requiring that the second person take without notice? And then is the statute, in addition to that, imposing on that second person the requirement that they be the first of the two to record? Okay, let's go back to the first page, or the second page, the first of my, page 3 actually, the first of my discussion. When I teach this, I like to make 2 points that I think will be helpful, and it's probably more helpful now that you've had some time to reflect on it rather than when you went through it. But I'd like to point out that recording acts, like many statutes, are displacing common law. So common law is your default rule. And it's important in recording acts to know that, because there are many times when recording acts, they're there, but they're not necessarily going to be applicable. So recording statutes will just have preconditions. Probably the most important precondition is they almost always require the second person to be a BFP. So they have to be somebody who purchased. So one of the things we'll be looking at is, well, what kind of statute is it? We just talked about that. And then the second thing that I think you want to address is, can the second person, when I say second person, I mean the person second in time, can they invoke the act? But what I mean by that is, can they avail themselves of the protections of the act? And that's critical. I like to look at recording act problems from the vantage point of the second person. You know, I'm always asking myself, can the second person win here? And the reason I do that is because the default rule is the first guy's going to win. So if we didn't have a recording act, first in time, first to get the mortgage, first to get the easement, first to get the deed, they win. And so sometimes if a recording act is not going to help the second person, which is what I say, the second person can't invoke the recording act. Again, the easiest example, the second person received their interest as a gift. So they're not a bona fide purchaser. And almost every recording act requires bona fide purchaser status in order to trump, if you will, the first guy, in order to displace the default rule. So if we can't invoke the act, use the act, then we're right back to the common law rule and we lose. So what kind of act is it? Can the subsequent purchaser, second grantee, however you want to describe it, can they invoke the act? That's my terminology. That's not any, there's no magic to that. Because I want you to distinguish between being able to invoke the act from being able, thirdly, to win under the act. Obviously, if you can't invoke the act, you can't win under the act. But it is possible that you are someone who could, again, to use my words, invoke the act, but not win. You're a BFP, so this act is at least potentially available for you to use, but you just didn't do what it required. So that was my sort of an overview, 3 steps. Again, I'll say it once again. What kind of statute is it? Can the second person invoke the act, and then can the second person win under the act? So with that in mind, let's look at these 3 types of acts, and then we'll discuss whether we can even invoke them. And I've got examples. You might recognize these examples, the people in them, maybe not. My first is the race statute, which I've mentioned already. So I have this example of somebody who conveys the same property twice. It's Thomas. So Thomas conveys the property to Daisy, but she doesn't record. And then he conveys the same property to Ethel, who has knowledge of the prior transaction. But of the two, it's the second person, Ethel, who records first. I have put here, Ethel otherwise satisfies the statutory requirements for invoking the act. Because even a race jurisdiction may only extend its protections to a subsequent purchaser who is a BFP. In fact, I think that is the case for North Carolina. So one question might be, is Ethel a BFP? Well, let's assume she was. So she can invoke our Race Act. Does she win under the Race Act? Yeah. She wins. What's the criteria for winning under a Race Act? Be the first to record. Does it make a difference whether you knew about the prior person or not? No, it doesn't make any difference. Ethel wins. That's all we need to know. Pretty easy, pretty straightforward. Perhaps unfair, but straightforward. Here's a point that I've had conversations with students. I hadn't thought about this, but I think it's worth sharing with you. I've had students come up to me and say, wow, I just took the Ohio bar and there were so many mortgage questions. I had all these mortgage questions. I'm like, oh, really? And then they would say something like, yeah, like here's one question that we had. Thomas mortgaged his property to bank number one. And then Thomas mortgaged his property to bank number two. And the question was like about the priority of whose mortgage was prior. And I'm sitting there thinking to myself, that's not a mortgage question. That's a Recording Act question that deals with mortgages. And I sure hope you knew that. I've also had a student once come up to me and say, there was a doctrine of worthier title question on the exam, or on the bar exam. And then they proceeded to tell me what it was, and I'm like, that's not a doctrine of that's over, so I just you got it right. So I make that point because, Thomas is not supposed to convey the same piece of property twice. That's a no-no. In theory, he really doesn't own the property anymore. But there's nothing wrong to create two mortgages. I can go out. I have a mortgage on my property now. I could go to another bank and seek another mortgage. So that's really, in a mortgage context, it's a priority dispute. In my example, if Thomas did mortgage his property to bank number one, and bank number one didn't record the mortgage, and then Thomas went out and recorded, sought a second loan and mortgaged his property a second time to bank number two, for example, in Ohio, because I mentioned Ohio is a race jurisdiction for mortgages, and if bank number two records their mortgage first, bank number two has priority. And that's true even if they knew about bank number one. It's in effect, shame on you, bank number one. You could have recorded first and you didn't. So we're going to, in effect, penalize you under the race jurisdiction. So these Recording Act questions don't simply deal with deeds. They deal with mortgages, also easements. I just gave my first years an exam, and I had a student say, well, Recording Acts don't apply to easements. They do. If I grant someone an easement, if I grant Megan an easement to walk across my property in a document, she doesn't record it. And then I sell my property to somebody else who has no notice of her under a notice statute, then they take free of the easement. So it applies to easements, documents, deeds, or mortgages, etc. Now, I want to go more to this next one and share with you the way I approach Recording Act questions. I find it helpful. And so I'm going to use this next pattern for both notice and notice race. What I like to do to help myself work out the sequence of events, which is obviously an issue with Recording Acts, it can be very much an issue with, you might have a chain of title problem too. And we're not going to get into that today. But where people don't record their deeds or documents immediately, and then they finally record them, and is it really in the chain of title? To me, what I think really helps me understand those is I'll put the date, or at least the sequence, and I'll have that in one column, and then I'll have what I'll call the transaction, in a second column, and then I'll have what I'll call the courthouse in yet a different column, because I want to see both the sequence of transactions, but also I want to see the priority or sequence at the courthouse, as I think will become clear. This stuff in the middle, it can be helpful. I'm not saying, I think it is helpful in recording acts. One of the things that you want to know, for example, is what type of document it is, and then what I put cash as opposed to like a gift. And that, of course, goes to BFP status. Sometimes I'll write in yet another column, if it need be, something like, because often they may or may not have actual notice. So I'll write over here, no actual notice. Because notice can be actual, or it can be constructive, or there's a sort of intermediate inquiry notice that's in the materials. But certainly, if it's recorded, then we're going to have, in our chain of title, we have notice whether we have heard about it or not. So in my example, this was the sequence. Sybil conveyed the property to Edith by deed for money, but she didn't record. If you want, you can put a line there. She didn't record it. Is that going to be a problem? I don't know. It depends on what happens next. Sybil, she's not supposed to do this because it's a property, but she did. She deeded it again, and she got even more money. Mary did not record it, at least on the 11th. So then we fast forward to the 15th of my problem, and it's Edith that finally gets around to recording. She waited, 13 days. And then shortly thereafter, a week after, it's Mary that finally records on the 22nd. Okay, so that sets up the problem, and the problem is going to be, we got to figure out who's, they'll typically tell you, but the problem in this case is you got two people that claim the same piece of property, Mary and Edith. I immediately then go to who was the second, who was the subsequent of the two. In this case, it was Mary. And again, this is where I think, well, Mary's not going to win under the common law rule. First in time wins. The only way Mary's going to win, once again, is if she can invoke the Recording Act and win under the Recording Act. So the invoke question pretty much goes to, at this point, is she a BFP? And she paid for it, so she is a BFP. So Mary can invoke the Recording Acts. There are some other sub-issues on that, but they're not present in this problem. But can she win over the Act? Well, what Act is it? It is a Notice Act. But let me make a quick observation. If the question had been a race jurisdiction, then Mary's not going to win. She can invoke the Act, but she's not going to win because she wasn't the first to record. But I'm asking it in the context of what's called notice, or sometimes pure notice. So what does that require? There it is. It only requires that the moment of the transaction, the moment of Mary's transaction, she took about notice. Took about notice of what? Of Edith, of the civil Edith deed. What is notice? Well, again, it could be actual notice. So what we're interested in is on May 11th, not thereafter, but just on May 11th, when that deed was handed to Mary, did Mary have actual inquiry or constructive notice of Edith? So that's why it would be important. I have it in the wrong place. It would be important to look very carefully at the facts to know whether on the 11th Mary had actual notice. And my fact pattern does not suggest that she did. In fact, I think I said had no knowledge of. So she didn't know about the deed on the 11th. She had no reason to investigate. That would be inquiry notice. There was no reason to make her suspicious in the fact pattern. So then it comes down to whether she had constructive notice. And the answer is, and we can see it in the courthouse column, no. The Edith deed was recorded after the 11th of May. So it's pretty straightforward. Mary can invoke the Recording Act because she's a BFP, the Notice Recording Act, and she can win. Yay, go Mary. things change, same fact pattern, but if we're in a race notice jurisdiction, we add that additional requirement. Can Mary win under the, or excuse me, I'm being very thorough today. Can Mary invoke the Recording Act, a race notice recording act? Yeah, she's a BFP, but can she win under it? Well, now she needs to take without notice, step 1, and record first, step 2. She meets step 1, as we just previously discussed. She took without notice on the 11th of May, but she didn't win the race to the courthouse. She delayed 11 days, and that proved to be fatal. Edith got in before she did. Sorry, Mary, you took without notice, but you didn't take without notice and record first. You can invoke the Recording Act, but you can't win under it, so that means Edith, and the only way that the number 2 person is going to prevail is if they can win under a Recording Act. You can't, Mary. You lose. So Mary wins under my notice problem. Edith wins under my notice race problem. I'll stop for a second. Any questions? Does it not surprise me that Mary beat Edith? Okay. Let me make a couple other points. On the next page 4, I've already to some extent gone over this. Again, I've set up a problem at the top of the page now with Matthew, Cora, and Lavinia, and it really comes down to this: can you invoke or can't you invoke concept? Let me then skip, because I think that can be picked up on page 5. So far, this conversation that I'm having with you about looking at it from the vantage point of the second person and asking, boy, they're not going to win under the common law rule unless they can use this Recording Act. So far, my only issue that I've described that might cause them to not be able to use the Recording Act is BFP status. And that probably is the main one, but I have another one for you here. So under part B at the bottom of page 5, I have an example. Not sure, I don't know if I want to go over this right now, but that is the question of who is a BFP and who is not. And I've given you 3 types of people that receive property interests, but without paying for them. Donees, people who are gifted property, but also people who are inherit property or receive property under a will. They don't pay for the property either. So watch out for that. If there's some sort of, he passed it at death to his son Bob, Bob's not a BFP. And if he previously sold it to someone, that could be a problem for Bob or whoever. But let me back up. This, I think, is a little trickier. I certainly went over this in class, actually in both property 1 and 2, that there's some kind of property interests that just simply are immune from recording acts. Recording acts are all focused on, you have a document that represents the property right, you really ought to record it. It makes sense to say to people, you don't have to record it. A transaction is valid without recording. But of course you run into this problem possibly of losing what you thought you had if you don't record. So that's why I always tell my students, practice prompt recordation. Go to the courthouse immediately. Don't walk. Run to the courthouse, because as soon as you record, boom, you've given everybody notice, and that's going to disable them from saying, I didn't know. But some property rights aren't memorialized in a document, which is to say they arise by law. And we're familiar with those. Adverse possession. If you complete 21 years of adverse possession, 5 elements in Ohio, you don't have a document. Somebody doesn't, walk out of the woods and hand you a document. Congratulations, you finally did it. He has a little microphone and it was 21 years. It was a really long time. I'd like to thank all the people. No, that doesn't happen. So, boom, you own it. But of course, there's nothing that says that, and in fact, there may never be. Ultimately, you might eventually go to court and get a document, like a judgment, that says, yes, you did do it, and you can certainly take that judgment to the courthouse and record it. But the point is, and here's my examples, and I said estates that arise by adverse possession. I'll throw this in real quick. Again, on my exam this year, first year, I had an adverse possession question, but I don't want to say I tricked my students. I made it slightly more difficult because the person who had the property interest only had a life estate. And so then I had this whole scenario where many years ensued, and eventually, yes, someone else adversely possessed the property, but the better students saw, I mean, at least for that question, that the title that the adverse possessor received was only a life estate. In fact, it was a life estate per atre v because it was measured by the person whose life estate they took. You know. And then, of course, I had that person die. So, you know, it was like I worked 21 years to get this stupid title, and it turns out that I only got a life estate, you know, measured by Fred's life, and then 3 days later he died. You know, so boom, it's gone. So the estate that we're talking about could be fee simple absolute, it most likely is, but it could be something else. Prescriptive easements, easements from pre-existing use, and easement necessities, you know, those also happen if you meet certain requirements, but they're not documents. As opposed to, you know, the types of property interests, if you have a deed or a will, or an easement that is written, an express easement, or a mortgage, or lease that you could record, it makes a difference. In my example there, I think it's worth our time to do this. I had Gloria adversely possess 4 of 40 acres, you know, probably on the one side of the property, let's say. Phil didn't know that, and he sold his acreage to Claire, and he purported to sell all 40. I'm going to stop real quick and interject here. This is a wonderful opportunity for the bar exam people to kill 2 birds with 1 stone, because my question is only geared towards recording acts, but could you see how they could easily throw in a title covenants question here? They could, you know, I didn't do it, but they could say stuff like, what if Phil gave Claire a general warranty deed? Well, he's promising her 40 acres, but he doesn't have 40 acres. But that's a different issue. He just sells the 40 acres. Claire has no idea, maybe there's no fence or anything that shows Gloria's assertion of the 4 acres. So she's innocent as to the 4 acres. She also is a BFP, and she records her deed. Can she invoke the act? Can she win under the act? If it's a race, well, actually any one of the 3, but I picked notice again. And the problem is that she can't invoke the act. And it's not because she's not a BFP. It's because, for her tough luck, she wants to say, I took free of a property interest. But unfortunately, the property interest that she is second to or wants to take free of is 4 acres that were acquired by adverse possession. And the acts don't help her. So she's not going to get those 4 acres by virtue of saying, hey, I'm a BFP and I didn't know about it and I took without notice, so don't I win under a notice act? And the answer is, yeah, you would have, except our recording act doesn't apply to title by adverse possession. Take this same fact pattern and change one fact. Suppose Phil had sold those 4 acres to Gloria and used a deed to do so. And then Gloria just didn't record. Now Claire's going to win. Because once again, she's a BFP when she thought she got 40 acres and paid Phil for it. But now, not only can she invoke the act, she can also win under the act because the act is applicable to documents such as the deed that Gloria received should have recorded and didn't. So the fact that Gloria took by adverse possession as opposed to deed, or if you want to use easements, if I grant Katie an express easement, you know, an easement that's in a document, well, she better record it, because I might sell my property to a BFP that doesn't know about it. On the other hand, if she just, you know, got an easement across my property through prescription, for example, then if I sell my property to somebody else, just like in the scenario, it's just tough luck for them. Also, again, with the easement problem, let me throw this in. Don't forget actual notice, or inquiry notice for that matter. So even if I sold if I sold the easement to Katie and she should have recorded it, but didn't, and then I'm selling my property to Blake. Blake, in that scenario, does not have constructive notice of the easement because Katie didn't record it. But there might be inquiry notice or actual notice because maybe there's a path or something across the property. Any type of notice, actual inquiry. If a reasonable person would say, what's that path, that they could figure out that it was due to an easement, then a court is going to say, no, actually you did know about it, or should have, a reasonable person should have known about it, and we're going to charge you with that. So that's more fact-based. Constructive notice is pretty much, is it in the chain of title or not? All right. At the bottom of page 5, I'm going to skip over this, but you can look at it later. That's just an example where the second person is not a BFP. Please bear in mind, however, that if you switch them, in other words, if grantee number 1 is a donee and grantee number 2 is a BFP, I gift the property to Anna, and then a week later, I sell the property to Carl. And once again, the lawsuit's going to be Carl versus Anna, and who's number 2 in that scenario? It's Carl. And this is why it's so important to look at recording acts from the point of view of the second guy. Because you don't want to get hung up on the fact that Anna's a BFP, or excuse me, a donee, that she got it by gift. It really makes no difference whether the first grantee is a donee, an heir, a devotee, or a purchaser. It only makes a difference whether they record it. So if Anna has got the gift and recorded it, well then Carl, who is a BFP, can invoke the act, but he can't win. Why? Constructive notice. On the other hand, if Anna didn't record her gifted property, Carl, as a BFP, certainly is entitled to say, hey, I can invoke the act, and I didn't know about it, I win. So it's really from the vantage point of the second person. Now, okay. Let me then throw one more thing at you. And this issue I was made aware of in the last couple of years was precisely the issue litigated by one of the major banks in Dayton. And that major bank was represented by a woman, Patricia Hill, who is a graduate of our law school. And she did an excellent job in the case. And she just like totally nailed the case for her client because she mastered recording acts. I think the reason that she was so good was she was Professor Durham's student. She wasn't one of my students. She did a good job. And here was the problem in the case that she worked with. It was 2 mortgages. And the problem from her vantage point was her bank was mortgage number 2. In other words, first bank 1 recorded, bank 2 recorded. And Ohio is a race jurisdiction as to mortgages. So her bank was in trouble. Her bank recorded second, so they lose. But her argument was, they looked carefully at the first recording, and they noticed that it was improperly notarized. And Ohio does have, as this suggests, that many recording acts say you don't get the benefits of recording acts unless you follow what we require, certain requirements. And one of the typical requirements is something about acknowledgments, which is done through notaries typically. And it was kind of a picky issue, really. There was it was notarized, but they left the person's name blank. You're supposed to fill in your name, and there was a seal, and there was a notary signature, and all that. But it wasn't fully compliant with the requirements. You don't have to notarize. I'm going to go out on a limb here. I'm almost 90% certain about this. You do not have to notarize a deed in Ohio for it to be valid, but you do have to notarize a deed and comply with the notary requirements if you want the protections of the Recording Act. And here's a bank number 1 that goofed, and bank number 2 said, yeah, ordinarily we would lose, but you didn't comply with the requirements, so you don't get the benefits of constructive notice. So we win. So yet another issue, I don't know if this will come up in the bar or not. So I have the example of Archie selling the property twice. It's the same scenario. The first time, though, it wasn't properly notarized, so the second person wins. Now, I mentioned chain of title. I think that's really a little bit off point, and I don't want to go into it now. So let's turn the page What you have here, and rather than going over this because we're getting near the end of the hour, I think this is great for my supplement. Some of these you got silly people and such, but there's 3 basic questions, but then there's suggested answers on the next page. So, you know, if you know, on a Saturday night, you can pull this piece of paper out and work on these problems rather than whatever else you want to do. And then beginning on page 9, you have real questions with these answers thereafter. So you've got questions 1, 2, 3, 4, 5. You know, let's just pick one random. I'll finish with this, and then you have a chance to get it. We can do it. I know somebody's going to come up with the correct answer. What about question 4 at the bottom of page 10? It all comes down to this. It turns out this year that rather than asking numerous questions, your particular bar exam is only going to ask you 1 question. You answer it correctly, pass the bar. You don't answer it correctly, you can always, you know, try to pass the bar some other time. And the 1 question they're going to ask you, there it is, bottom of page 10. Which of the following parties cannot be protected as a bona fide purchaser? Clock ticks. We have to carefully read the question. It's not can be protected, it's cannot be protected. Well, we wouldn't want to make that mistake. Cannot be protected. Any thoughts on this? What about the first one? Can a donee, would it be correct to say that a donee from a bona fide purchaser cannot be protected? Questions now I'm starting to sweat here. This question is the only one. Any thoughts? Don't cheat. Likely good.
Doesn't the shelter doctrine apply?
You know, I'm glad you raised that, and we could talk about it, but I'm going to think that you've overly complicated the problem already. I'm going to guess that you've overly complicated the problem already.
Okay.
We've got donees, purchasers, from heirs. We've got devisees and mortgagees. Do we want to take a shot, or are we just going to sneak and look at the end? Oh, come on, somebody. Josh, lay it on the line for me.
Oh, come on.
All right. Nobody wants to say? All right, well, we're going to cheat. What do they say? C, a devotee cannot be protected. That was actually a harder question than I thought it was. Let's look at this. We're running out of time. I'm sorry. Because they go on and say the others. A mortgagee can be protected as a BFP. That makes sense to me. A purchaser from an heir, that cannot be protected. They're as a BFP. Blah, 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 blah. And donee from a bona fide purchaser can be protected. Have I just left us in a ball of confusion here? I thought that was going to be a straightforward answer, but I've got to actually personally sit down and think about that one for a second. Yeah.
They mentioned the shelter doctrine, that's why.
You did, didn't they?
Yeah, that's why the donee.
Did you look at that beforehand?
No. I just happened to remember that.
The donee from a bona fide purchaser? Yeah. Well, shoot, I wanted in with a bang and I ended with a whimper. Sorry about that. That is a harder question than I thought. But I hope that, I'll have to look at that again. It does illustrate, though, the complexity of these types of questions. You start with the basics, and that's what we talked about today. But I'm actually, in one respect, I'm glad I raised that, because things like shelter rule and chain of title issues, they do impact.